Awesome.
We're live.
Excellent. So welcome everybody to the 2023 Rookie Rumble final round. Representing the state, so you guys can pop your cameras on, is Team 32. Welcome, Team 32. And then representing the defendant, Kendall Whitley, is Team 46. You guys want to pop your camera on. Welcome, Team 46. Excellent. So now I'm going to go ahead and turn it over to Adam to introduce our first judge for today's final round.
If Nathaniel Warner can please turn on his camera. Nat Warner will be our first final round judge. Nat competed at Wesleyan University and graduated in 2017. And since then, he's coached a few pretty notable programs. He's coached Wesleyan, he's coached Columbia, and he's currently the head coach of Northwestern University. In his 6 years coaching, he's coached at least one team to place at nationals every single year, sometimes even two. Welcome, Nat Warner.
If we could have Brad Wombo turn on his camera. Hello, Brad. So this is Brad. He's a graduate and former competitor of Miami University and currently coaches at Case Western. He's also one of the people who helped author the case that you're going to be using in this final round. So do it justice.
And then coming up next, Elise, if you could flip on your camera. And Elise Wilson, in addition to being a current board member and member of our primary CIC, Elise also competed at UNC Chapel Hill, coached for Georgia Tech, and to lead the stream of people that know this case inside and out, was the chair of our case writing committee for this year.
All right, and I have the honor of introducing our fourth judge, if Delois could turn on her camera. And so Delois is another AMTA board member and the chair of AMTA's academics committee. She's also possibly one of the most decorated coaches in AMTA, winner of the W. Ward Reynoldson Award for her team winning the national championship in 2009, elected to AMTA's Coaches Hall of Fame in 2016, and the winner of the Neil Smith Award in 2019. So thank you, Delois.
And if I could get Mr. Jonathan Woodward on the screen. Lacking a cheese hat, but we will work with it. This is Jonathan Woodward. You should all know is the current president of AMTA. He'll be your presiding judge today. And he is the author of the tabulation manual, which we have had a few run-ins with this tournament. He is a human encyclopedia of college mascots and is very excited to be joining us here on his Sunday evening to be judging this final round.
Jonathan, we'll turn it over to you. You can start our final round.
Excellent. Thank you all. And I will call the case of State of Midlands versus Kendall Whitley, case number 23 CR 317008. If I could have appearances from counsel, please.
May prosecution make appearances?
Yes.
Good evening, Your Honor. My name is Haley Faroki, and today I'm joined by my co-counsel, Miss Lydia Ferris.
Good evening, Your Honor.
Today we represent the State of Midlands.
Thank you.
After opposing counsels made their introductions, we just have a few housekeeping matters.
We'll get there in due course. Ms. Faroki, appearances from the defendant.
Yes, Your Honor. Good evening. My name is Emberlyn St. Hilaire, and today I'm joined by my co-counsel, Mr. Elijah Bull.
Good evening, Your Honor.
And together we represent the defendant, Mr. Kendall Whitley.
Good evening.
All right, the record will note those appearances. The court has reviewed the stipulations that the parties have reached, as well as Judge Young's pretrial order that was entered on June 13th, 2023. So I don't believe any further discussion is necessary as to those matters at this point in time. Certainly, Council can bring those up during trial to the extent that they're relevant to an issue that is before the court. Beyond that, Attorney Ferocki, anything else that needs to be taken up outside the presence of the jury?
Yes, Your Honor. First, we'd just like to ask your permission to use a couple of exhibits during our opening statements. Well, we'll just be referencing them for the convenience of the jury.
Are these exhibits that have been deemed pre-admitted?
Your Honor, they haven't been pre-admitted. However, we do have a good faith belief that they are admissible and will be admitted during our case in chief.
Attorney St. Hilaire, what's your position on that request?
If we can know what exhibits opposing counsel is referring to specifically?
We'll simply be referencing exhibits 8 and exhibits 11.
Yes, Your Honor, we would have an objection to that, to opposing counsel using that during opening statements.
May I be heard, Your Honor?
Very briefly.
Your Honor, we actually have a good faith belief that under State v. Dembski case law, these exhibits aren't objectionable. They're actually verbal acts. They constitute the extortion itself. We're simply providing them for the convenience of the jury.
But they haven't been offered into evidence yet. There's been no witness that's testified to them, so the request is denied. Anything else, Ms. Ferocki?
Yes, Your Honor. For the sake of time, we'd just like to ask that all exhibits prior to admission just be constructively considered outside the view of the jury.
They will be.
And throughout today's trial, we have a timeline that we're going to be displaying. It's already been shown to and approved by opposing counsel. We just ask that that be considered constructively outside the view of the witnesses.
Attorney St. Hilaire, what's your position on that?
If opposing counsel can explain exactly what she means by that?
I'm confused by that too. What do you mean by that?
Your Honor, we're just simply stating that witnesses aren't necessarily allowed to view these demonstratives, such as a timeline under 615 sequestration, because there will be evidence from prior testimony. So we just ask that they be considered outside the view of the witness. That way we're not violating any rules.
I can't necessarily agree to that request. Demonstrative aids have to be viewed by the witness. So if there's something from prior testimony that's on a visual aid, you need to make sure the visual aid doesn't reference the prior testimony. So I can't just come up with a rule that says witnesses can't look, that there's some sort of a visual aid that a witness isn't allowed to look at. So that request is denied. Anything else, Ms. Ferocki?
No, Your Honor. With that, we're ready to proceed to openings.
Okay, Ms. St. Hilaire, anything from the defendant before we bring in the jury?
Yes, Your Honor. First, both parties have seen and signed an intent to offer character evidence form. Is it okay if we put that in the chat for you now?
Yes, that would be great. Thank you.
Next, Your Honor, we'd like to draw your attention to a piece of case law, State v. Meyer. It's on the top of page 3 of your bench book.
I'm familiar. I've reviewed the case law that's applicable to this matter. And certainly if there's anything that comes up during the course of trial, we can address that at that time.
Perfect, Your Honor. And since we've never had the pleasure of serving in your courtroom before, we ask your preference on objections. Should we move to strike or consider it stricken?
In the interest of time, you can consider it stricken.
Yes, Your Honor. And when we're screen sharing exhibits, should we just note for the record or ask your permission?
You can just note it for the record. Again, that'll all be deemed constructively outside the presence of the jury until such time that an exhibit has been received into evidence.
Yes, Your Honor. And with that, we're ready to rumble.
Excellent. I'm just getting the character evidence form up here. I just lost it, so I need to get it back here. All right. Okay, so I do have that should we need it at a later point in time. And we'll now go in the presence of the jury in the matter of State versus Whitley. And Ms. Ferocki, you may present your opening statement whenever you're ready.
Yes, Your Honor. For the promotion, he chose extortion. It's the summer of 2022, and the defendant, Mr. Kendall Whitley, has one job: to get the company he works for, Sahara Land and Midlands, to build a warehouse. But there's a problem. See, a beloved theme park sits on that land, and the owner doesn't want to sell. So the defendant turns to the mayor of Breckenridge County, Miss Devin Sullivan. And today you're going to learn that the mayor has power. The power to force the sale of private land. That's called eminent domain. You're going to learn that the defendant pushes the mayor to use this power. But the mayor refuses. And you're going to hear that the CEO of the defendant's company, he's getting impatient. He tells the defendant, "We can't wait around forever for the mayor to change your mind. Your promotion is on the line. And for the promotion, the defendant chooses extortion. He blackmails the mayor, threatens to release a fake article accusing the mayor of taking bribes, accusing the mayor of abusing her power, accusing the mayor of corruption. And he leaves the mayor with no choice. The next day, the mayor announces she's taking that land. And the defendant, well, he gets his promotion. That's why today we've charged the defendant with extortion. And with that, we've taken on a burden of proof to show you three very simple things throughout today's trial beyond a reasonable doubt. First, we're going to show you that the defendant threatened to accuse Mayor Sullivan of a crime. Second, that the defendant intended to cause fear with that threat. And third, that the defendant's threat played some role, any role, in Mayor Sullivan taking that land. We're going to show that to you by calling two witnesses to the stand. First, you're actually going to hear from the mayor herself, Mayor Devin Sullivan. She's going to tell you about a fake article she found on her desk accusing her of soliciting bribes. You're going to learn that on August 30th, Ms. Sullivan met with the defendant. And during that meeting, the defendant threatened to release that fake article and told her political career was over if she even thought about not announcing she was taking the land the next day. Now, we expect the defense at some point might get up here and try and argue that no, that meeting, it never happened. But what you're going to hear is that the defendant's car was seen at City Hall that very day. And so second, you're going to hear from an undercover officer working in Mayor Sullivan's office at the time. Now, he's going to be showing you two documents accusing the mayor of soliciting bribes. First, that fake article found in the mayor's office. And second, an investigative report by a private investigator the defendant hired in the defendant's office. Now, when the officer compares these two reports, members of the jury, you're going to see for yourself that large portions of both of these documents are identical. Same words, same structure. Members of the jury, they're even going to have the same punctuation. The evidence is going to show you that the defendant used that investigative report to create that fake article threatening the mayor. Now, you might hear throughout today's trial that there were multiple parties who wanted Mayor Sullivan to take that land. But the evidence is going to show you is that only the defendant had that identical report. Only the defendant hired a private investigator to gain leverage over Ms. Sullivan. Only the defendant had a promotion on the line. Now, there's nothing wrong with a company working with a mayor to better their community. There's nothing wrong with that. But when a person uses threats and blackmail to get a promotion, members of the jury, that's extortion. That's why at the end of today's trial, my co-counsel, Ms. Ferris, is going to stand before you, and she's going to ask you to find the defendant guilty. Thank you for your time.
Thank you, Attorney Faroki. Counsel for the defendant, Attorney St. Hilaire, you may proceed when you're ready.
Yes, Your Honor. Your Honor, Ms. Faroki, members of the jury. The mayor made a mistake, so she made up a story. It's August 31st, 2022, and Mayor Sullivan is standing at a podium. There are cameras flashing to her left and right, and in front of her is a sea of reporters. The whole county is holding their breath as she announces her decision to tear down a local amusement park and let a company named Sahara build a warehouse on that land. But you see, this wasn't a decision the mayor took lightly or made on some sort of whim. No, she had been studying the numbers, and it told her one story. As unemployment was rising, the people demanded jobs. But for the next 2 months, in the midst of her re-election campaign, her approval ratings start plummeting. Her inbox gets flooded with hate mail every single day. Her name is blasted on the front page of every newspaper in town because of this decision. The mayor is drowning in a wave of backlash. But she can't understand why. Because she thought surely Sahara and the 5,000 new jobs it would bring to her county would be the solution the people wanted. But ultimately, the mayor made a mistake. And when she realizes that that mistake could cost her her re-election, she tries to save the drowning ship. You're going to learn that she makes up a story. That this decision, well, it wasn't really hers. That you can't blame her, that she was extorted into doing it by an employee of Sahara, Mr. Whit. And that's why we're here today. Because of that story, a man who is just trying to do his job is on trial for extorting a government official. And when the prosecution decided to run with the mayor's story, well, they took on the burden of proof. They have to prove to you today that Mr. Whitley threatened to expose the mayor's secrets, that he used fear to intimidate, and that the mayor made his decision because of that fear. They have to prove each one of these elements beyond all reasonable doubt, the highest burden in our legal system. That means at the end of today's trial, if you feel like the mayor's story is just not making sense, if you feel like she's making it up, well, you can't find Mr. Whitley guilty. And trust me, today there will be plenty of reasonable doubt because of two simple facts. First, the mayor's story just can't be trusted. And second, the evidence points to a different story entirely. Now let's start with that first fact. Fact one, that the mayor's story can't be trusted. When you look at the state's case today, you're going to see too many holes to count. No security footage, no eyewitnesses, no forensic evidence that can tie Mr. Whitney to the delivery of that blackmail. You're going to see that it very well could have been the mayor herself that made it up. And that brings us to fact number two. We're going to prove that the evidence points to a different story by calling two witnesses to the stand. First, you're going to hear from the mayor's former staffer. And he's going to tell you that the mayor came to her decision after months of studying the numbers. And those numbers made it look like the people wanted Sahara to come in and bring them their jobs. It was only after all the criticism started, after it all started crumbling down, well, that's when the mayor started trying to point the finger somewhere else. Then you're going to hear from Mr. Whitley. And he's going to tell you point blank he never sent any blackmail. Not only because it's not in his character, but because he didn't need to. That after him and the mayor sat down and discussed the number, the mayor was on his side. Members of the jury in this country, our elected officials, our presidents, senators, representatives, and even our mayors, they make tough decisions every single day. They try their best, but sometimes they make mistakes. You're going to learn today that making a mistake isn't the problem. The law tells us that using that mistake as a reason to make up a story, well, that is. That's why at the end of today's trial, my co-counsel, Mr. Bully, is going to ask you for the only just verdict, a verdict of not guilty. Thank you.
Thank you, Attorney St. Hilaire. I'm going to pause for a moment here to allow the jurors to finish up their notes. In the meantime, counsel for the state can work on getting ready for their first witness. Is the state prepared to call its first witness?
Yes, Your Honor. We'd like to call Mayor Devin Sullivan to the stand.
Mayor Sullivan, can you hear and see us?
Yes, sir. Can you hear and see me okay?
Yes, thank you. I'll remind you, you've previously been sworn. Attorney Faroki, you may go ahead with your examination.
Good evening. Could you please introduce yourself to the court?
Good evening. My name's Devin Sullivan.
Ms. Sullivan, what do you do for a living?
I'm the mayor of Breckenridge County. Going on 12 years now.
How'd you become mayor?
I started out teaching third grade, actually, down at Booker T. Washington. And I love the kids, bless their hearts. But their books were just falling apart. And I told the school board, I told the city council, they just didn't do nothing about it. So I got myself on that council, ma'am. Kids got their books. And I've been doing this kind of thing ever since.
So why are you here in court with us today?
I'm here because last year, Sahara, the shipping company, one of their managers came into my office and threatened me. He said if I didn't do exactly what he said, he'd release some article to the news saying that I took a bribe.
And I want to make one thing very clear for the members of the jury. As mayor of Breckenridge County, have you ever accepted a bribe?
No, I would never.
Then why are you willing to talk about this now?
I didn't tell anyone at first because I didn't think that anyone would listen. But then I told my assistant, Ron, and he did listen to me. And I thought that maybe if Ron believed me, then maybe everyone else would too.
Ma'am, I want to give you a chance to talk about your relationship with the defendant. When did the two of you first meet?
March of last year, around March 2nd, we met face to face. He came in, introduced himself as a regional manager, and he said that Sahara, the company, they wanted me to use eminent domain on this theme park so they could build some warehouse over it.
Ma'am, would you mind explaining to us real quick what exactly eminent domain means?
Sure. Sometimes the government can take private property from private citizens if we think it's for the general good of the people. As mayor, I had that power, eminent domain. So I would be able to force the theme park owner to sell his land to Sahara, even if he didn't want to.
Ma'am, so after the defendant asked you to use this eminent domain, what'd you decide to do?
I politely declined. I wanted to go to the people first to ask them what they wanted more, that theme park or the warehouse.
Your Honor, permission to display a timeline?
Is this to the jury?
Yes, Your Honor.
Mr. Bully, any objection?
Not at this time, Your Honor.
Go ahead.
We're going to be placing March 2nd. Mayor declines to use eminent domain on that timeline. Ma'am, so you told us at first you declined to use eminent domain. Well, did you ever change your mind?
I went back and forth over the next couple of months, but in the end, no. From what I saw with my interactions with people, they seem to want the theme park a whole lot more than some warehouse.
Objection, Your Honor, to speculation.
May I respond, Your Honor?
Go ahead.
Your Honor, this witness is simply giving her explanation as to why she made the decision she did.
Mr. Bully, your response?
Yes, Your Honor. The reason for that decision is based on speculation. She can't say what people would have wanted without stepping into their mindset. This
May I be
testimony
heard?
is-
That's not necessary. I'm going to overrule the objection. I think the jury understands that the witness is referring to her perception of others' beliefs and not necessarily speculating as to what they actually believed. You can inquire further on cross, Mr. Bully. Next
Yes,
question.
Your Honor.
Ma'am, did you ever tell the defendant that you weren't going to use eminent domain?
I did. I left him a voicemail around August 23rd. I thought it'd be polite to let him know before I told the public.
So I want to talk about whether or not the defendant chose extortion because of that voicemail you left. Ma'am, did you ever get to tell the public that you weren't going to take that land?
No,
Why not?
the day after I tell Kendall Whitley no, I come into my office and the first thing I see just lying on my desk is his article with a whole bunch of lies about me.
Would you recognize that article if I were to show it to you?
I would.
Permission to display what's been pre-marked as Exhibit 11?
For identification purposes,
Yes, Your Honor.
go ahead.
Ma'am, do you recognize this?
I do.
What is it?
It's that article I found on my desk.
Would you say it's fair and accurate?
Yes, ma'am.
The prosecution moves Exhibit 11 into evidence.
Any objection to the receipt of Exhibit 11, Attorney Bully?
Pursuant to the precedent State v. Dembski, no objection.
Exhibit 11 is received.
Ma'am, what does this article say about you?
Well, at the top, it says blood is thicker than justice. And then it accuses me of accepting a 50 grand bribe and pressuring the DA to let someone out of jail. And at the bottom, they've even attached a copy of my campaign's bank statement.
Your Honor, at this time, we're going to be displaying that timeline again for the jury. We're going to be placing August 24th, Blood is thicker than justice. Fake article in mayor's office. Ms. Sullivan, after you received that article, what did you do?
I met with Mr. Whitley again, about a week later on August 30th.
And during that August 30th meeting, what did the two of you talk about?
I didn't talk about much, ma'am. But Mr. Whitley came in. He said he left a folder for me. He said that it was his career on the line too. And if I didn't make the announcement the next day that I was going to use eminent domain, he was going to release that article so quickly, I wouldn't be able to even dream of having a political career ever again.
After the defendant threatened your political career, Ms. Sullivan, what did you do?
I did the only thing I thought I could do. I thought if the article got out, no matter what I said, people would just look at me like some kind of criminal. So I made the announcement the next day. I let them have the theme park, and I let them build their warehouse.
Your Honor, at this time, we're going to be displaying that timeline for the jury. We're going to be placing August 31st, Mayor uses eminent domain.
Hang on, Attorney Faroki. Did we have testimony from the witness that happened on August 31st?
Yes, Your Honor. She just testified that the next day, after that August 30th meeting, that she used eminent domain. Thank you for your time. Oh, yes, Your Honor.
I didn't hear that exact date, August 31st, that the witness testified to. Attorney Bully, do you agree that that's what the witness testified to?
That's what I heard, Your Honor.
Okay, great. Go ahead.
No further questions at this time. Thank you, Ms. Sullivan, for your time.
Attorney Bully, go ahead with your cross, please.
Yes, Your Honor. Good evening, Mayor Sullivan.
Good evening.
Can you see and hear me okay?
Yes, sir, I can.
Great. I want to start off with why you forced the Sahara. Now, you'd agree that to be elected mayor, you have to make campaign promises.
That's true, sir. You have to run a campaign, you gotta have a platform, and then you gotta win the vote.
It's important for public servants to keep their promises.
That's true, sir.
Ma'am, you promised to fix the economy.
When I ran for mayor back in 2007, yeah, that's right.
When you ran for mayor, you promised more jobs for Breckenridge.
15 years ago, that's right, sir.
Ma'am, last year, you were having trouble keeping that promise, weren't you?
That's correct. COVID had hit the county pretty hard, so our unemployment was higher than I would like.
It was on the rise last year.
It was.
So when Mr. Whitley pitched the idea of a new warehouse to you, you were ecstatic.
That's right, sir. Before I heard the catch about the theme park, I was ecstatic. It sounded like a win-win for everybody.
You thought this win-win would bring new jobs to your county.
That's what I thought, sir.
Mr. Whitley told you there could be 3,000 people employed at that warehouse.
I believe he gave me a range, sir, somewhere between 1 and 3,000. That was the upper limit. That's correct.
So when you announced that you were forcing that deal, you called it the best thing for Breckenridge.
That's what I had to tell the people. That's correct, sir.
Well, if that's what you were telling the people then, I want to talk about what you're telling them now. Now, just a moment ago on direct examination, I wrote it down. You said, the only thing I thought I could do was choose Sahara. Did I get that right?
That's right, sir. Mr. Whitley said if I didn't, he'd ruin my career.
Let's talk about your options. Now, when you walked into your office and you saw a file on your desk You could have chosen to call the police.
That's right, sir. I just didn't know who it came from, so I didn't.
You didn't check the security cameras to try to find out who did it.
No, sir, I didn't think to do that at the time.
You didn't think to look for a sign-in sheet.
A sign-in sheet, sir?
A sign-in sheet for City Hall?
We don't got a sign-in sheet, sir. We have an electronic system.
You never checked that electronic system.
No, sir, I wouldn't be able to.
You didn't think to call someone who could?
No, sir.
But you're telling us that Mr. Whitley came into your office and put that file on your desk.
I didn't see him, sir, but when Mr. Whitley came into my office a week later, he said he put the folder there. That's what he said.
So you're telling us that Mr. Whitley came into City Hall on a workday.
I don't know when he put it there, sir.
Ma'am, you found the folder on August 24th.
That's right.
That was a workday.
It was, sir, but I don't know when exactly he could have put it there.
You're telling us that Mr. Whitley came into your office through the doors, right?
I suppose.
Objection, Your Honor, as to vague. May I be heard?
Very briefly.
Your Honor, what time frame we're referring to, whether it's that August 30th meeting or the defendant supposedly taking in that article into the mayor's office, I don't believe the question was very clear as to which instance opposing counsel was referring to.
Seemed very clear to me he was referring to the folder being placed in the office, so the objection is overruled.
Yes, Your Honor. Mayor Sullivan, you're telling us that Mr. Whitley walked through the doors of City Hall to put that folder on your desk.
Sure, sir. I guess I don't believe that he climbed in a window.
And then he made it all the way back out without anybody seeing.
I don't know if anyone saw him, sir. I couldn't tell you that.
You don't know of anyone who saw him.
That's right, sir. I couldn't tell you. You'd have to ask someone else.
Ma'am, I want to talk about someone else who could have put that folder on your desk. You found a copy.
Objection, Your Honor. Opposing counsel is testifying. He just made an assertion of fact in his preface to the question.
Overruled.
Mayor Sullivan, you found a copy of your personal calendar in that folder, right?
That's right. My personal calendar from a few years ago.
Ma'am, you have access to your personal calendar.
That's right, sir. I do.
You found copies of your bank statements in that folder?
Not my bank statement, sir. No.
You found a copy of the bank statement from Sullivan for Breckenridge, right?
It was from an organization supporting my campaign, if that's what you're referring to.
Sullivan for Breckenridge, that's your PAC, isn't it, ma'am?
Yes, sir. It's an organization supporting my campaign.
You found a copy of the bank statement in the folder.
That's true.
Ma'am, you could get access to that bank statement.
I suppose so.
You also found details about your cousin's robbed armory charge.
They mentioned that Pax was charged with armed robbery a few years ago. That's right.
Ma'am, you knew all of those details about your cousin's armed robbery charge.
That he was charged at one point and then let go. That's right.
Ma'am, you didn't find any instructions in that folder?
Instructions for what, sir?
Instructions to use eminent domain. There was nothing like that.
No, Whitley didn't tell me to use eminent domain until I met with him a week later.
That folder didn't say force the deal for Sahara.
No, sir. It just had this sticky note on the top saying, "We know what you did."
Ma'am, I'm going to go out on a limb here and say you have a printer in City Hall, don't you?
Yes, sir, I do.
And you happen to find this folder when no one else was around to see.
Yes, sir. It was in my office. I don't let just anyone in my office.
Ma'am, on August 24th, you found that folder early in the morning, right?
That's right. First thing when I came into work.
First thing, you were the only person in the building at the time.
Yes, sir.
And after you found that folder, you didn't tell anybody for another 3 months.
That's right. I didn't know what Whitley would do if I did.
Ma'am, I want to talk about what changed for you in those 3 months. You review polls with your staff every single month, isn't that right?
That's correct.
After you announced you were forcing the Sahara deal, your approval rating plummeted.
That's right, sir. It was exactly what I've been worrying about.
The news was calling that decision a dagger to your career.
Yes, sir.
Your own staff told you you made a mistake.
That's correct.
They said that was the worst choice you could have made.
Yes, sir. That's why I didn't want to make it.
And it was only after the people turned on you that you ever claimed you were blackmailed.
It was after I told my assistant. That's true.
Ma'am, after you claimed you were blackmailed, your approval rating came right back up.
It did.
You want everyone to know you were blackmailed now.
Of course, sir. I want to set the record straight.
You're setting the record straight using a media tour?
Yes, sir. I want to let the people of Breckenridge know I'm their representative.
You've been going around giving talks for the last 3 months.
That's right.
On this tour, you tell this story as a part of your election campaign.
It's not a story, sir.
Ma'am, you told them what you told us today as a part of your re-election campaign.
That's right, sir. I went and told the public the truth about what happened because I felt like they needed to know the truth.
You came to court today and told us the exact same story.
That's correct, sir. I told the truth, and the truth stays the same no matter what.
Thank you, Mayor Sullivan. No further questions.
Thank you, Attorney Bully. Attorney Farocki, any redirect for the witness?
Yes, Your Honor, briefly. May I proceed?
Go ahead.
Ms. Sullivan, opposing counsel asked you a question I found interesting on cross-examination. I wrote it down just to make sure I get it right. He asked you if you were given instructions when you were given that threatening article on your desk. Ma'am, how did that indicate to you that you needed to use eminent domain?
Well, it was the day after I told Mr. Whitley no, and then I saw a note on top that said, "We know what you did." And then after when I met with Whitley, he said he left the folder there, ma'am.
Ma'am, opposing counsel keeps saying that you're telling us a story, but I want to ask you, is anything you've said today in court a story?
No, it's the truth.
Thank you, Ms. Sullivan. Nothing further, Your Honor.
Thank you, Attorney Bully. Any recross?
No recross based on that, Your Honor.
All right,
May
thank
this
you.
witness be excused?
Yes, thank you for your testimony this evening, Ms. Sullivan. You are excused.
Your Honor, just for clarification, is prosecution allowed to proceed?
I'll invite you to proceed in just a moment. All right, Attorney Ferris, you may proceed with examination of the state's next witness.
Prosecution calls Ryan Sawayama to the stand.
Mr. Sawayama, can you see and hear us okay?
Yes, Your Honor, I certainly can.
All right, I'll remind you, you've previously been sworn. Attorney Ferris, you may proceed with your direct examination.
Yes, sir.
Good evening. Could you please introduce yourself to the members of the jury?
I will. Good evening, lasses and lads, and of course the honourable lad. Today I'll be testifying under the pseudonym Ryan Sawayama.
Sir, why are you testifying under a pseudonym?
Well, I'm an undercover agent for the Midlands Department of Justice, the Special Investigations Unit. To preserve me former and active covers, the Honourable Judge Young has agreed to protect my identity.
All right, well, sir, what can you tell us about your background?
Well, after earning a bachelor's in criminal justice, I was recruited to skip law school and joined the Midlands Department of Justice. After graduating from the academy with honours, I started working exclusively on government investigations.
So, Detective, what brought you to this case?
Well, while working undercover as Mayor Sullivan's secretary, my unit arrested the regional manager of Sahara, a lass named Kendall Whitley, on charges of extortion.
All right, well, Detective, I want to start by talking about whether or not you've ever heard the defendant threaten the mayor. Sir, do you recall an instance where you remember the defendant threatening the mayor?
Yeah, that I do. One time I saw Kendall Whitley get up and he told the mayor, Sahara will be a dangerous enemy, and you'll be sorry if you don't go through with using eminent domain.
Now, sir, after the defendant threatened the mayor, did you ever find anything threatening in the mayor's office?
That I did. I was in her office, watering her plants. Actually, I switched most of them out with plastic ones by that point. She hadn't really noticed, but I found a fake article accusing the mayor of accepting a bribe.
Once you found that fake article, sir, what did you do?
Well, at that point, we decided to figure out where the folder with this article, where it originated from.
All right, well, sir, let's talk about the evidence you found through your investigation to see who was responsible for placing that fake article in the mayor's office.
All righty.
Sir, where did you start your investigation?
Well, I was instructed by my unit to start with the defendant's office the very next day.
How were you able to access the defendant's office?
Well, see, one thing I learned in the academy is that in America, people remember a posh Irish lad with an accent, but no one remembers a backwards cap American. So when I walk in, I swap this for a backwards cap tank top. And they ask me, what are you doing here? Well, I go, nothing, bro, just stretching the legs. Works every time.
All right, sir, well, once you gained access to the defendant's office, did you find anything?
It was a typical corporate office, no windows, lots of files. So I started rummaging through them. See, I found a report from a private investigator and a handwritten note in Miss Whitley's office.
Sir, would you recognize that report and the handwritten note if we showed it to you?
Why, that's I would. I was the lad who found it.
Your Honor, permission to screen share Exhibit 8 and 15 constructively outside the presence of the jury.
You may.
Sir, do you recognize these two images?
That I do. That right there is the report, and then the other one is the handwritten note I found in Mr. Whitley's office.
Now, do the two appear to be a fair and accurate representation on the screen?
Aye, both fair and accurate.
Prosecution moves to enter Exhibit 8 and 15 into evidence.
Attorney St. Hilaire, let's start with Exhibit 8. Any objection to Exhibit 8?
Yes, Your Honor, to hearsay.
If I may be heard.
Attorney Ferris, what's your response to that?
Your Honor, we're not using Exhibit 8 for its truth. And frankly, Your Honor, we actually don't agree with the contents of the document for its truth. It accuses the mayor of a crime that we don't believe the mayor committed. Furthermore, Your Honor, this is an admission by party opponent under 801 D2D.
Attorney St. Hilaire, what's your response?
Yes, Your Honor. As to this being an admission by a party opponent, that foundation has not been laid. The witness testified that this was from a private investigator, Carson, who is not a party opponent in today's case.
What's your response to that, Attorney Ferris?
Your Honor, it's already on the record that this was a private investigator report. Furthermore, Your Honor, the defendant has a sworn testimony where they admit that that report was created by someone they hired in order to create that report. Under 801 D2D, this satisfies the, Your Honor, this satisfies the party opponent admission as the private investigator Carson was an employee to the defendant.
Response, Your Honor.
Yes, go ahead.
For this to be an admission by a party opponent, we would have to have that foundation already on the record. The defendant hasn't testified yet, and this witness cannot lay the foundation for that, for 802 D2 to apply in this case.
If I may be heard.
Let's go back. I'm not too worried about the party opponent issue, but I am worried about the effect on the listener argument. Ms. St. Hilaire, can you respond to the effect on the listener argument that the state is making?
Yes, Your Honor. This document is being used for the truth of the matter asserted, that this is indeed what that investigator found, and that it was a well-kept secret, but not impossible to find. All these statements are being used for the truth of the matter asserted, that this is what that investigator found.
If I may be heard.
Final word on that, Ms. Ferris.
Your Honor, we're actually not trying to use this for its effect on the listener. We do assert that we're offering this for a non-truth purpose. This exhibit is going to be used as circumstantial evidence because it ties the fact that the defendant was behind the creation of the fake article. If I may make an offer of proof.
Go ahead.
Your Honor, we're going to be showing the jury that the last paragraph of Exhibit 8 is almost virtually identical to the fake article found in the mayor's office. This is circumstantial evidence that the defendant used that report to translate that information into the fake article.
All right. The court needs a moment just to re-review the content of Exhibit 8.
Yes, Your Honor.
Going to overrule the objection, and Exhibit 8 will be admitted. Any objection to Exhibit 15, Attorney St. Hilaire?
No objection.
All right, Exhibit 15 will be admitted. Next question, please.
For clarification, Your Honor, are Exhibits 8 and 15 in evidence?
They are.
All right, Detective, I want to break down what you found in the defendant's office, starting with that investigative report. Sir, what was significant about it?
What's interesting is that last paragraph there is virtually identical to the last paragraph of the fake article I found in the mayor's office. See, if you look at that green highlight there, you see the green. Right? See, they both read at 11 a.m. DA Dolar's office released a statement that charges against Pac Sullivan will be dropped due to lack of evidence. I mean, you can look right there. It's even got identical punctuation.
Sir, you just told us that the report you found in the defendant's office has a paragraph that's virtually identical to the fake article found in the mayor's office. What about the handwritten note? Is there any connection to the fake article there?
I was speaking about the note circled right there at the bottom is the phrase, blood is thicker than justice. It's just like the title found in the note in the mayor's office. Right there.
Your Honor, at this time, we're going to be screen sharing a timeline. We're going to place August 26th. Private investigative report found in defendant's office. Blood is thicker than justice, handwritten note in defendant's office. Now, detective, after you found the evidence in the defendant's office that were connected to the fake article in the mayor's office, what did your unit decide to do?
Hey, well, at that point, my unit had enough evidence to arrest Mr. Kendall Whitley on charges of extortion.
Thank you, detective. Your Honor, I have no further questions.
You're welcome.
Attorney St. Hilaire, your cross.
Yes, Your Honor. Top of the evening, detective.
I get what you're saying. Top of the evening, lass. How are you?
I'm good. Sir, you'd agree with me that you fabricated and lied about evidence before, right?
Well, lass, right off the bat, it was back in 2013. I had a disciplinary report.
Right, sir. Back in 2013, you submitted witness statements to a court to get a search warrant, right?
That's right, Mom. I was new to my unit, and my boss ended up. Well, he pressured me to submit those exaggerated statements, which I did.
Sir, that wasn't quite my question. You'll have plenty of time on redirect to explain, but this is very important.
Yes, Mom.
You submitted witness statements to a court to get a search warrant, right?
Yes, Mom. That I did.
You signed those statements as truthful and accurate.
That I did, Mom. Back in 2013.
But sir, you exaggerated facts in that witness statement.
That I did, Mom.
You invented facts in that witness statement.
Objection, Your Honor. More prejudicial than probative, pursuant to 403, if I may.
No, overruled.
Sir, you invented facts in that witness statement.
I exaggerated some details, Mom. You have that right.
Ma'am, sir, you lied in that witness statement. Yes or no?
Yes, Mom. I did.
And you did that at the time because you believe that's what your police department just did. Do I have that right?
Yes, Mom, you do. I was new to the unit, and my boss pressured me to do so.
Okay, sir. Well, I want to talk about if you fabricated evidence in today's case.
I certainly did not.
Well, sir, if I could get Exhibit 15 up, that's already been entered. Sir, you claim that you found this piece of paper in a folder in Mr. Whitley's office, right?
You have that right, Mom. You do.
But I want to be crystal clear for the members of the jury. What we're looking at right now is just a picture of that piece of paper.
That's right, Mom. When I was in Mr. Whitley's office, I took that picture you're looking at right now.
Sir, there's no timestamp on here to tell us when you took it.
Well, no, there's no time stamp on the image.
There's no location tag on there to tell us where you took it.
No, Mom. There's no location tag. I just took it in at Mr. Whitley's office.
Detective, there's nothing in the background of that picture to confirm that this was taken in Mr. Whitley's office, is there?
Well, Mom, you see the bit of our computer, Mr. Whitley's computer there, his desk, but I took a picture of the note that you're looking at. You have that right.
Sir, Mr. Whitley's name is nowhere in the background of that photo.
No, it's not on the paper with the title either, Mom.
Well, sir, not only do we not have any of this information, we don't have the actual physical piece of paper with us today, do we?
Oh, certainly not, Mom. I wasn't gonna take it from me while I was just in the 30 seconds there I was in the office.
Well, sir, let me be a little more clear. After Mr. Whitley was arrested, a collection team went in and did an official search of Mr. Whitley's office, correct?
That's right, a few months after I did.
And that paper, well, it wasn't where you told them it would be, right?
They didn't find it.
Sir, the folder was there, but the only document missing was that piece of paper. Isn't that true?
That's right. My unit didn't find that piece of paper, not like I found it.
Sir, so today, to the best of your knowledge, you're the only one testifying that this paper actually exists, correct?
Well, Mr. Whitley would, certainly.
That's a yes to my question. You're the only one testifying that this existed?
Objection, Your Honor, lacks personal knowledge.
Response, Your Honor?
I think that objection is sustained. You can argue to the jury who testified as to why it's not appropriate for him to comment on the testimony of other witnesses.
Yes, Your Honor. Sir, today all we have is your word that this paper actually existed, right?
Well, the photo, Mom.
Well, sir, tell me this. At the time that you found that folder, you'd been undercover in the mayor's office for about a year.
That's right, I have about a year before I found that photo.
Your original assignment was to find corruption in the Board of County Commissioners.
That's right, that's where I first started working undercover at the mayor's as the mayor's secretary. But as I was there, as you said, Mom, that's when I found that note.
After 365 days, you didn't have a lead.
Pardon?
After 365 days working in that office, you didn't have a lead on corruption on the board, did you?
Oh no, Mom, I was looking at extortion now.
You didn't have a witness.
A witness to what, Mom? I'm sorry.
Detective, you didn't have anything to show your bosses about corruption on the Board of County Commissioners, yes or no?
That's right, Mom, I was there for a year. There wasn't any corruption.
That's a yes to my question. You couldn't show your bosses anything.
But I didn't find anything, Mom.
Well, of course, till this case came along, right?
That's right, when I saw the extortion, the evidence of extortion, certainly.
Sir, and you'd agree that that piece of paper we were just looking at, well, it makes your case against Mr. Whitley, it made it a whole lot stronger, right?
Well, it's not my case anymore, Mom. I've moved on since this.
That wasn't my question, sir. When you found that piece of paper, you built your case around, didn't you?
That's not true.
So you're saying that piece of paper didn't have any effect on your investigation?
Certainly, Mom. But after I found that piece of paper, I turned the investigation over to my unit, and they conducted interviews and searches without me, and they decided to do what they did.
Okay, so, well, we talked a little about if we could trust your word. I want to talk about if we can trust the mayor's word. Because, sir, I want to talk about that folder of blackmail in the mayor's office. You were undercover in that office again for an entire year, right?
Yeah, that's right. I was there for almost an entire year as the mayor's secretary.
You never saw anyone drop off that folder of blackmail, right?
No, Mom, I didn't see someone put the folder in the mayor's office. Yeah, that's right.
None of the other staffers that worked in that office told you they saw someone drop off that folder of blackmail.
Yeah, no, they did not.
You didn't review security footage of someone dropping off that folder of blackmail.
City Hall's a busy place. I had no idea at the time who could have or who did. I didn't check any of the security footage.
That's a yes to my question. You didn't have security footage of someone dropping off that folder, right, sir?
No, yeah, that's right, Mom. No security.
Evidence that someone broke in and dropped off that folder.
No, Mom, I didn't think of anything of a break-in.
Sir, you didn't do fingerprint testing on that folder.
No, again, that wasn't my responsibility. I was merely the undercover officer at the scene.
So, sir, you can't exactly tell us how that folder got into the mayor's office, can you?
I have absolutely no idea.
To the best of your knowledge, sir, the only person other than the police that's touched that folder is the mayor, right?
Objection, Your Honor. Lacks personal knowledge.
Response, Your Honor.
Go ahead.
The witness can answer based on what they know.
And the question called for the witness to answer based on his knowledge, so the objection is overruled.
Sir, to the best of your knowledge, besides the police, the only other person that touched that folder is the mayor.
I have absolutely no idea, Mom.
Well, sir, the only other person you've seen touching it is the mayor.
I haven't seen the mayor touch the folder. I found the folder in the mayor's office.
Well, the mayor told you that she touched that folder, sir, right?
No, she never told me she touched the folder. She told me she was extorted.
Sir, is it your statement today that the mayor told you she didn't find that folder in her office?
She did found the information in the folder. I don't know whether she touched it or not. But I'm guessing she did, certainly.
Thank you, sir. No further questions.
You're welcome, Mom.
Thank you, Attorney St. Hilaire. Attorney Ferris, any redirect for this witness?
No redirect, Your Honor, if this witness can be excused.
Yes, thank you for your testimony. You are excused.
Thank you.
Any further evidence or testimony on behalf of the state?
The prosecution rests its case in chief, Your Honor.
All right, very well. Current time is 6 minutes after the hour. Let's stand in recess for 5 minutes till 11 after. All right, it is 11 minutes after the hour, so we'll go back on the record in the matter of State versus Whitley. I note that the appearances are the same. Counsel for the state, are you prepared to proceed? Attorney Ferris, are you ready?
The state is ready, Your Honor.
Okay, and is the defendant prepared to proceed as well? Everyone's back that needs to be back.
Defense is ready to proceed.
All right, Attorney Bully, please call your first witness, please.
The defense calls Joey Lakes to the stand.
All right, good evening, Mr. Lakes. Can you see and hear me as well as the attorneys?
Oh, yes, Judge.
Very well. I'll remind you, you've previously been sworn in. You're under oath, and Attorney Bully, you may proceed.
Yes, Your Honor. Good evening. Please introduce yourself to the members of the jury.
Hi there. My name is Joey Lakes.
What do you do for a living, Mr. Lakes?
I'm a part of the best baseball team in town, the Midlands Jumbo Shrimp.
The Jumbo Shrimp? Do y'all play in the majors?
Oh, not exactly. We don't practice very often, and sometimes we still drop the ball, but we always pick it right back up. I like to think we're on our way to the majors.
What's your job on the baseball team?
I'm a data scientist. I crunch the numbers for the team. Hitting percentage, range factor, isolated power. If you can name it, I can count.
Well, how are you involved in today's case?
Before I got started with the Jumbo Shrimp, I used to work for the mayor, Mayor Devin Sullivan. I crunched the numbers for her re-election campaign.
Sir, why are you testifying today?
Well, back in October, the mayor fired me. I'm here to tell my side of the story.
Let's start at the beginning. What did you do in the mayor's office?
Back then, I was looking at polling data instead of batting averages. I was hired to take a look at the polls, and then I would analyze those polls and develop strategies for the mayor.
Those polls you looked at, do you know where they come from?
The people. If you've ever gotten one of those calls from a pollster asking you for a few seconds of your time, and you didn't hang up the phone, you'd see that those pollsters, they're trying to gauge the temperature of public opinion.
Which opinions?
Over at the mayor's office, I focused on the approval ratings, as well as the top issues for voters and the unemployment rate here in Breckenridge.
Would you recognize the data you reviewed?
I sure would.
Your Honor, at this time, defense is screen sharing Exhibit 5, Exhibit 6, and Exhibit 7. Mr. Lakes, do you recognize all this data?
Oh yes, give me a second. Yes, this is all of the data that I reviewed.
Is it a fair and accurate copy?
Yes.
Has it been changed or altered in any way?
Not that I can tell.
And did you share all of your findings with Mayor Sullivan?
Oh yes, that was part of my job.
Defense offers Exhibits 5, 6, and 7 into evidence.
Attorney Ferris, any objection, keeping in mind Judge Young's pretrial order dated June 13th?
Yes, Your Honor. Lack of foundation for Exhibits 5, 6, and 7, and hearsay to Exhibit 6.
All right, let's start with the hearsay argument on Exhibit 6 and just talk about Exhibit 6 to start. What is your hearsay objection to Exhibit 6?
Your Honor, the pretrial order by Judge Young, it doesn't admit Exhibit 6, and it doesn't bar it from any hearsay objections. It only bars any poll data. Exhibit 6 isn't poll data, it's statistical information from the Midlands Department of Labor.
Okay, Attorney Bully, what's your response to the hearsay argument with respect to Exhibit 6?
Yes, Your Honor. Firstly, it is our understanding that this data is included in the poll grouping. Secondly, we're also offering this not for the truth of the matter it asserts, but to the effect of the listener. The same exception that the prior ruling had.
If I may be heard.
Go ahead.
Your Honor, there's actually a reason why Judge Young didn't include Exhibit 6. That's because it would be used for its truth. The unemployment record would be offered for its truth to prove the current unemployment rate of Breckinridge County. Now, for the poll data, sure, opposing counsel can use it for its effect on Mayor Sullivan, but the Midlands statistical analysis, that would be coming in for its truth.
Attorney Bully, any other reasons you believe Exhibit 6 is admissible?
Your Honor, we maintain our position. We're not offering this for the truth, merely the effect it had on the mayor. We're not concerned whether or not the employment rate was actually poor, but that she believed that it was.
Do you have a response to that, Attorney Ferris?
Yes, Your Honor. Your Honor, pursuant to case law, opposing counsel would have to prove that Exhibit 6 was actually viewed by the mayor and it affected the mayor's decision. Now, the mayor specifically looked at poll data, not the unemployment rate in Breckinridge County.
Well, what's your response to that, Attorney Bully? So I think the
We've already-
testimony was a little bit different.
Yes, Your Honor, we've already laid this foundation. I asked Mayor Sullivan if she reviewed polls with her statistical team every single month. She said yes. I asked Mr. Lakes if he shared all of his conclusions from this data with the mayor, and he said yes. It's within her knowledge, and it would weigh in her decision-making.
If I may, Your Honor.
No, I'm going to overrule the objection to Exhibit 6. I think there are other reasons why this is admissible, even though they haven't been cited by counsel, but Exhibit 6 is admissible. Let's turn back to Exhibit 5 and its various subparts. Attorney Ferris, what is the grounds for your objection to Exhibit 5 one more time?
Lack of foundation, Your Honor, if I may.
Go ahead.
Your Honor, the witness hasn't laid any foundation as to how these poll data is created. It's important for the members of the jury to hear how this poll data is created, who looks at them, what exactly they are. All opposing counsel's questions were, do you recognize this? And all the witness stated was yes. They didn't elaborate as to how they recognize it.
Your response, Attorney Bully?
Yes, Your Honor. Firstly, that foundation is on the record. I asked Mr. Lakes if he knew where this poll data came from. He explained the process of pollsters calling up members of the community and asking for their opinion. Secondly, opposing counsel's objection goes to weight, not admissibility. If she doubts the reliability and the sources of these statistics, she's free to cross-examine on it.
I tend to agree. I think this is within the scope of the pretrial order. Certainly, it's fair game for cross-examination, which would also be admissible. So I'm going to allow Exhibit 5 to be admitted. Attorney Ferris, what is the grounds for your objection to Exhibit 7?
Your Honor, it was also lack of foundation. This poll data is collected differently from Exhibit 5. It wouldn't fall under the same foundation as Exhibit 5.
What's your response, Attorney Bully?
Your Honor, that foundation is on the record. It's our understanding this data was collected the exact same way. It may be from a different source, but the polling still stands.
Well, again, the court's not expressing any opinion as to the validity of the polling, but pursuant to Judge Young's pretrial order, I think the conditions precedent to admission have been met. It's been shown, it's been communicated, and it's being used to show the effect on the mayor or the defendant. So you can go into it on cross, but otherwise the objection is overruled.
Yes, Your Honor. Mr. Lakes, what did all this data show you?
You know, it's one thing to look at a pile of numbers, but it's a whole nother to see the story behind them. And to tell that story, I brought along a little presentation I put together.
Your Honor, permission for Mr. Lakes to show his presentation? Prosecution counsel has seen it.
Attorney Ferris, any objection?
No objections, Your Honor.
Go ahead.
All right, Mr. Lakes, what are we looking at here?
Well, right now, nothing. We're looking at a blank chart showing the mayor's approval rating as it changes from month to month, based exclusively on that data that I reviewed.
Where does this story begin?
Well, it begins in March. That's when I first learned that the mayor met with Mr. Whitley. And the most recent polling at the time had the mayor at 65% approval.
Did the mayor's approval rating stay at 65%?
Oh no, over the next few months, it started to drop. until in July it was at 50%.
What was going on in July?
Let's take a closer look. We know that in July, the unemployment rate was on the rise, almost 2% above the state average.
What did the polls say about unemployment?
Well, a poll taken in a local Midlands paper had jobs listed as the top issue for voters.
Well, how did the mayor's office respond to this data in July?
In the mayor's office, we were considering the Sahara deal, tearing down a local amusement park and building a new warehouse. A new warehouse needs new people to work in it.
Did the mayor make that Sahara deal?
Oh, yes. In August, the mayor announced that deal.
Mr. Lakes, what happened to the mayor's approval rating after she announced the deal?
Well, it was more of a strikeout than a home run. The mayor's approval rating went all the way down to 29% in August and in September.
How did that affect things at the mayor's office?
The mayor had announced she was running for re-election, so all hands were on deck to save her campaign. We had a meeting to talk about those polling numbers.
Let's talk about what happened in that meeting. What was the first thing you said?
Well, I came to that meeting with an idea. I thought if we held a press conference and really apologized for tearing down Rock the World, that it would help. And I told my plan to the mayor.
Objection, Your Honor, hearsay.
Attorney Bully, your response?
Yes, Your Honor. We're using this to show the subsequent action of the mayor. If I may proffer.
Go ahead.
My next question is going to ask how the mayor responded, and he's going to tell the members of the jury that the mayor fired him.
Your response, Attorney Ferris?
Your Honor, that subsequent action wouldn't be relevant because by then the extortion would have already happened. Opposing counsel would need to show that it's relevant to the members of the jury to show the subsequent action and how it affects the fact of consequence in today's case.
Attorney Bully, final word?
Yes, Your Honor. We're also going to elicit a statement from the mayor stating their state of mind at the time in response to Mr. Lakes' suggestion.
I think this in general goes to the defense's sort of alternate theory, and so I'm going to allow the defense some leeway to present that to the jury. So the objection is overruled.
Yes, Your Honor. Mr. Lakes, how did the mayor respond when you suggested that she apologize?
Well, she said, if you think what I did was so wrong, maybe you should find another candidate to support. And then later that day, she called me into her office. She said she was planning on going in a different direction, and she fired me.
What happened after the mayor fired you?
I know now that she went in a different direction. She claimed she was extorted.
Mr. Lakes, after the mayor claimed she was extorted, what happened to her approval rating?
Since September, the mayor's approval rating has climbed back up. The most recent polling has the mayor at 47% approval and neck with her election challenger.
Thank you, Mr. Lakes. No further questions.
Thank you, Attorney Bully. Attorney Ferris, your cross, please.
Good evening, Mr. Lakes.
Good evening, ma'am.
No, sir, earlier on direct examination, you told us how unemployment was a concern during July. Do I have that correct?
That's absolutely right.
Well, sir, I want to actually talk about how much of a role that poll data played into the mayor's decisions in August.
Of course.
Your Honor, we're going to be apologies. Did I cut you off?
Oh no, ma'am. I said, of course.
Your Honor, we're going to be displaying Exhibit 5B.
Okay.
Now, sir, this is the poll data that you told us on direct examination you relied on.
That's right.
Now, according to this poll data, it says unemployment was a top issue in July of 2022, just like you told us on direct examination, right?
That's right. These polls are taken right at the end of the month, so right at the end of July.
Sir, it also says it was an issue in June of 2022. Isn't that true?
Oh yeah. It's an important issue here in Breckenridge.
Sir, it's not just an important issue. It's considered a top issue, right?
For sure.
Now, that's also the case in May of 2022. Isn't that true?
Objection, Your
absolutely.
Honor, substantially more misleading than probative.
How so?
Your Honor, we already agreed not to use this data for the truth of the matter asserted, but rather the effect on the mayor. Right now, Ms. Ferris is reading this data as if it's true that people actually consider these the most important issues.
I'll let you respond in a moment, Mr. Ferris, but I don't understand there is any such limitation on these exhibits. You asked that they be admitted, so they're admitted. And opposing counsel is free to ask questions about them on cross. Ms. Ferris, do you have any further response?
Your Honor, I happen to echo the same message.
All right, this is fair game, Mr. Bully, overruled.
Yes, Your Honor.
Now, sir, in May of 2022, unemployment was considered a top issue, wasn't it?
That's right. It was either the #1 or #2 issue on every month on this chart.
Exactly, sir. Every single month in that poll data, unemployment was a top issue, wasn't it?
That's exactly right.
Now, Mayor Sullivan, she didn't announce that she's going to use eminent domain in July of 2022.
That's right. She announced it in August when those July numbers would have been the most recent poll.
So, sir, that's a yes to my question. She didn't announce eminent domain in July of 2022, right?
Right. It was in August.
So that also means she didn't announce in June of 2022.
No, August and June are different.
Right. So, sir, every single month when unemployment was considered a top issue, the mayor didn't announce she would use eminent domain.
That's right.
So I want to look at why the defendant didn't use eminent domain in the months leading up to August. Sir, you're familiar with an organization called AMTA, right?
Oh yes, I sure am. I've got a souvenir baseball from them, actually.
That's great. So, sir, you're very familiar with AMTA, is that right?
Yes, the Association of Midlands Treasures and Antiquities.
So then, sir, you'd also be familiar that in May of 2022, AMTA announced that they would back a challenger against the mayor if the mayor said that she would use eminent domain. Do I have that right?
Right, they announced that.
So, sir, after this announcement from AMTA, the mayor said, we don't want to fight with AMTA. Isn't that true?
That's right, back in May.
She told you, sir, that if we're going to win this election, we need their support. She said that to you, didn't she?
Yes, she did.
Now, sir, between the statement from the mayor on August 30th, the mayor didn't say a word about using eminent domain, did she?
Oh, that's right.
Sir, what you can tell us is that it was on August 31st. That's when the mayor announced she'd forced the sale of the land, right?
That's when she made her formal announcement, absolutely.
So, sir, I want to look at whether or not the defendant was with the mayor the evening before she made that announcement. Now, sir, just a day before, on August 30th, you saw a parked car in the parking lot of the mayor's office. Do I have that right?
Oh, that's right. I saw a few parked cars in the parking lot.
Now, this was at around 5:45 p.m.
Right, that's when I left the office that day.
Now, you remember you saw a black car, right?
Yes, a few black cars.
Well, you saw a black G-Wagon. Isn't that true?
Oh, yes.
Sir, that car that you saw in the parking lot of the mayor's office, it looked just like the one you had seen the defendant step out of before. Isn't that true?
I know that Mr. Whitley also drives a black G-Wagon. I just can't tell you if the two cars are the same.
Sir, redirecting you back to my question. That car you saw parked in the evening of August 30th, it looked just like the one you had seen the defendant step out of before. And that's a yes, isn't it?
They were both black G-Wagons, if that's what you mean.
Sir, that's a yes to my question?
Yes.
Sir, you can't tell us why that black G-Wagon was in the City Hall parking lot on August 30th, can you?
Oh no, I have no idea.
What you can tell us is just one day after that car was in the parking lot, The mayor announced she would use eminent domain. Is that true?
That's right. That's when she told me.
Thank you, Mr. Lakes. Your Honor, I have no further questions.
Thank you, Attorney Ferris. Attorney Bully, any redirect for this witness?
No redirect examination. We just ask that Mr. Lakes be excused.
Thank you for your testimony this evening, Mr. Lakes. You are excused. And we'll pause here a moment to allow the jury to catch up on their notes, and we'll be with you in just a moment, Attorney St. Hilaire. All right, Attorney St. Hilaire, please call your next witness.
Yes, Your Honor. We call Kendall Whitley to the stand.
Mr. Whitley, can you see and hear us okay?
Yes, Judge.
All right, I'll remind you, you've previously been sworn in. Attorney St. Hilaire, you may proceed when you're ready.
Good evening, sir. Could you introduce yourself to the court?
Hi. My name is Kendall Whitley.
Mr. Whitley, have you been sitting in trial throughout its entirety?
Yes, ma'am.
Have you heard the allegations the state has been making against you?
Yeah. Yeah, I know what they're saying about me.
Well, sir, I want to give you a chance to respond right off the bat. Did you ever send the mayor a folder of blackmail?
No, absolutely not.
Did you ever threaten the mayor during a meeting on August 30th?
No. No, I didn't have a meeting with the mayor that day.
Sir, did you extort Mayor Sullivan at any point?
No. I didn't.
Sir, let's take things from the beginning. How'd you start working at Sahara?
Well, I'm originally from the West Coast. I grew up in California. After college, I just started applying to some jobs and Sahara hired me.
What work did you do for them?
I started in the mailroom, grabbing coffee orders for the office, that type of thing. But eventually I worked my way up to regional operations manager.
Could you tell us what a regional operations manager does?
Well, it sounds really fancy, but really I just worked on outreach for our location right here in Midlands.
What was it like working in that position?
I liked it. A stable income, good hours. I got to spend a lot of time with my daughter. It was a good job.
I want to turn your attention to the mayor now. How did your relationship with Mayor Sullivan even start?
Well, Sahara, my company, we wanted to build a new shipping center over Rock the World, this old amusement park.
and it was my job to speak with the mayor.
Why'd you have to speak to the mayor?
Well, the owner of the park didn't want to sell, so we wanted to see if the mayor would use eminent domain to buy the land.
When was your first conversation with her?
Our first conversation, we had a meeting in March of 2022.
Can you tell us about that meeting?
I thought it was great. I gave the mayor my pitch. We had a really nice conversation.
Well, how did it end?
Well, it was our first meeting, so, no determinations were made at that point, but the two of us kept in contact.
So on your end, how did you proceed with that deal?
Well, I wanted to know a little bit more about the mayor, anything she was interested in, maybe a political passion project. So I hired an investigator to see if there was anything else we could bring to the table.
Did you find what you were looking for?
No, I was looking for something to help, but instead I received this pile of dirt.
What do you mean by a pile of dirt, sir?
Well, I received this information tying the mayor to some scandal, something to do with her cousin. I mean, I don't really know, but it certainly wasn't what I was looking for.
Did you use this information to make blackmail?
No, I didn't.
Your Honor, at this time, we're screen sharing Exhibit 11, which has already been entered. Sir, did you write this article?
No, I wouldn't ruin someone's life for a warehouse.
Okay, sir, if you didn't use any of the information your investigator gave you, how did you try to win the mayor over?
Well, I relied on the numbers. Like the gentleman just before me said, unemployment was up and jobs were the number one issue to voters.
Do you know if the mayor saw these numbers at any point?
Yeah. I had a meeting with her in July where we discussed them.
What happened during that meeting?
Well, we discussed this jobs issue, and I told her how we had a solution. 5,000 new jobs.
When you told the mayor Sahara could bring her 5,000 new jobs, what was her response?
She says, maybe I'm right.
So what happened?
The mayor went through with the deal. She did. I was excited. I sent her this thank you email. And over at Sahara, we got started on the project.
So, sir, why are you sitting here in court today?
Well, 2 months after it's all said and done. I remember I was leaving my office and just about to say goodbye to my secretary. There were all these police officers in the office. They were everywhere. They grabbed me and they put me in handcuffs and they said I was being arrested for extortion.
Thank you, sir. No further questions at this time.
Attorney Faroki, you're crossed.
Yes, Your Honor, may I proceed?
Go ahead.
Good evening, Mr. Whitley.
Good evening, ma'am.
During the summer of 2022, you wanted a promotion at the company you worked for, Sahara, right?
A promotion's always nice.
So that's a yes. During that summer, you wanted that promotion?
Well, I wouldn't turn a promotion down, so sure.
So I want to talk a little bit about that promotion because you and your CEO, you emailed about that promotion, right?
That's right, ma'am. That's how I found out that perhaps I could get this promotion if the deal went through.
So you'd recognize those emails if I were to show them to you?
I'm sure I would.
Your Honor, permission to screen share what's been pre-marked as Exhibit 2B for identification?
Okay.
Sir, you recognize these as those emails between you and your CEO, yes?
Yeah, these are some emails between me and my CEO. That's right.
You'd say they're fair and accurate?
Yes.
We move Exhibit 2B into evidence.
Attorney St. Hilaire, any objection?
No objection, Your Honor.
Exhibit 2B is received.
Sir, I'd like to direct your attention to that bottom left email right there. You'd see that was sent on July 19th, 2022 at 9:21 a.m. Did I read that right?
You did, ma'am. That's right.
And in this email, your CEO tells you, can't wait around forever for the mayor to change your mind. Your promotion is on the line. Did I read that right?
Well, I can't see the first part anymore, but I think that is, yeah, that's right.
And sir, the next email is you telling your CEO that you understood, right?
That's right.
Your Honor, at this time, we're going to be displaying a timeline for the jury. And we're going to be placing July 19th, defendant is told promotion is on the line. Sir, you said something on direct examination. I just want to confirm whether or not that's true. You said, I wouldn't ruin someone's life for a warehouse. I have that written down here. You said that, right?
That's right. I said that.
Well, I want to talk about whether or not you'd ruin someone's life for a promotion.
I
Because,
wouldn't.
sir, on April 10th, you hired a private investigator. Yes or no?
That's right.
Your Honor, at this time, we're going to be displaying that timeline again and placing April 10th, defendant hires private investigator on it. Sir, you'd recognize emails between you and your private investigator, right?
I'm sure I would.
Permission to screen share exhibits 3B and 3D.
You may.
Sir, you recognize these as those emails, yes?
Yes, that's right.
You'd say they're fair and accurate?
I would.
Your Honor, we're going to move exhibits 3B and 3D into evidence.
Attorney St. Hilaire, any objection?
No objection, Your Honor.
Exhibits 3B and 3D are received.
Mr. Whitley, directing your attention to exhibit 3B, these are from July 19th at 9:30 a.m., right?
Yes, ma'am, that's correct.
Sir, just to make something clear for the members of the jury, that's the same day your boss told you your promotion is on the line, yes?
That's right. I sent this, I believe, after, or at least the same day as the other emails.
You didn't just send it the same day, sir. You actually sent it 9 minutes after your boss told you your promotion is on the line, right?
Yes, that's correct.
So 9 minutes after your boss told you your promotion is on the line, you emailed your private investigator, I need leverage, fast. Did I read that right?
That's right. I thought we could use some leverage.
And you got that leverage on August 22nd, didn't you?
No.
I want to talk about whether or not that's true. Because, sir, directing your attention to exhibit 3D on the screen in front of you, you'd see those are from August 22nd, right?
Yes, these emails were sent from on August 22nd. That's right.
I want to clarify something for the members of the jury. That's just a week before the mayor announced she was going to take the land, right?
Yeah, I believe so. It was around that time.
So just a week before the mayor announced she was going to take the land, your private investigator tells you, call me ASAP. Did I read that right?
Yes, that's what my private investigator said.
And then you told your private investigator something, didn't you?
Yeah, I believe there was a follow-up email.
Exactly. Then you told your private investigator just a week before the mayor announced she was going to take that land. You told your private investigator you were worth every penny. Did I read that right?
Yeah, I mean, even though I didn't use what they gave me, I didn't want it to seem like they wasted their time.
So that's a yes to my question, sir. You told him that just a week before the mayor announced she was taking the land.
That's right.
Your Honor, we're going to be screen sharing that timeline again. And we're going to be placing August 22nd. Defendant emails private investigator, you were worth every penny. Well, sir, I want to talk about why you thought your private investigator was worth every penny. Because just a week after you sent that email, the mayor announced that she was going to take the land, right?
Yeah, like I said, they were around the same time.
Sir, just a week after you told your private investigator you were worth every penny, you got your promotion, didn't you?
The deal went through, and I was promoted.
Thank you, sir. Nothing further, Your Honor.
Thank you, Attorney Faroki. Attorney St. Hilaire, any redirect?
Yes, Your Honor, briefly.
Go ahead.
Mr. Whitley, did the promise of a promotion drive you to commit a crime?
No. Yeah, I figured there'd be promotions down the line, but I wouldn't do anything criminal for a promotion.
Well, sir, following that July 19th email, what leverage did you actually bring to the mayor?
Numbers.
What numbers?
Unemployment rates, voter issues, those are what I used with the mayor.
Thank you, sir. No further questions.
Attorney Faroki, any recross?
No recross, Your Honor.
All right, thank you for your testimony, Mr. Whitley. Any further evidence or testimony on behalf of the defendant?
No, Your Honor. The defense rests.
All right, I am showing 48 minutes after the hour. We will stand in recess until 55. All right, I have 55 minutes after the hour, so I'm going to call the matter of State versus Whitley back on the record. We are outside the presence of the jury for the moment. First of all, is everyone ready to go from the state?
State is ready, Your Honor.
Attorney Bully, you ready to go?
Defense is ready.
Okay, and anything that needs to be taken up outside the presence of the jury before closing arguments?
None from the prosecution.
None from defense, Your Honor.
Okay, very good. We'll go back in the presence of the jury, and Attorney Ferris, you may proceed with your closing argument when you're ready.
The defendant's career was on the line. The defendant was desperate. And when he realized he was one warehouse away from a promotion, one fake article away from a promotion, he chose extortion to get that promotion. Earlier today, my co-counsel, Ms. Faroki, she showed you a checklist. Our job today was to check off every single box on this list, to prove to you each of these facts beyond a reasonable doubt. And today we did that. We proved that the defendant threatened to accuse the mayor of a crime. The defendant intended to cause fear. And as a result, the mayor used eminent domain. But members of the jury, here's the thing about proving extortion. We don't have to show you it was the only cause. Just that it was a thumb on the scale of justice. That it played some role in the mayor's decision to use eminent domain. So I want to walk through how we proved each element of extortion. Let's start with the first fact. The defendant threatened to accuse the mayor of a crime. Now, members of the jury, both sides, we already agree that the defendant wanted the mayor to use eminent domain since March 2nd. But it was only on August 31st that the mayor announced she would force the sale of the land. So what happened in those 5 months between March and August? The defendant became desperate. His promotion was on the line, the clock was ticking, and he couldn't take no for an answer. So he created a fake article to accuse the mayor of a crime. Now the defense, they got up here and they tried to act like that handwritten note was our smoking gun and that Detective Sawayama fabricated it. Members of the jury, that doesn't make sense. Detective Sawayama didn't need to fabricate anything because we have a mountain of evidence that the defendant created that fake article. The handwritten note, that was just the cherry on top. Because we showed you how the defendant, he hired a private investigator. Members of the jury, if you hire a private investigator, you're looking for private information. And the defendant, he didn't sit on them and wait. No, he chose to act. And in cases like this one, the defendant chose to use them to his advantage to get that promotion. And we know this is the case because of the defendant's own words to that PI. You are worth every penny. We showed you how the defendant used that report that was worth every penny to write that fake article. Because when you put one next to the other, they're the same. Two different documents found in two different locations with the same exact structure. You're telling me that's not the defendant's? Because at that point, members of the jury, you'd be doubting your own reason. And the defendant, he said it himself. Coincidence after coincidence after coincidence ceases to be a coincidence and becomes evidence of guilt. Members of the jury, creating a fake article, leaving it in the mayor's office, that's the defendant threatening to accuse the mayor of a crime. Next, we prove to you that the defendant wanted to use that fake article to scare the mayor into using eminent domain. And when you think about it, the defendant didn't just walk up to the mayor and say, do this or else I'm losing a promotion, or else I'm going to back a challenger, or else I'm going to work against your policy. No. Instead, the defendant chose to threaten the mayor with something much more serious and long-term. Her career. I will release that fake article so quickly that you have no chance of thinking about a political career ever again. If that's not intended to cause fear, I don't know what is. Because when the defendant dangled the mayor's political career in front of her eyes, he chose to do that knowing he could scare the mayor into action. Members of the jury, we've proven the second fact. So that brings me to the final element. We had to prove that as a result of threatening to release the article, the mayor used eminent domain. Now, this is where the defense got up here and told you the defendant's actions, it played no role. They brought up poll numbers, they brought up unemployment. But there's two problems with this story. First, there's no evidence that unemployment or poll data played any role in the mayor's decision. Members of the jury, all they've given you to chew on, it's a story about how unemployment's always been an issue. And second, members of the jury, it doesn't matter if poll data or unemployment played into the mayor's decision. Because if you believe the defendant's actions only played some role in the mayor's decision, our work here is done. Now, throughout this trial, you saw us building this timeline. Now, this is the first time you've seen it all together. But from that timeline, we know that on August 31st, the mayor, she chose to use eminent domain. But what happened just a day before? The defendant's car was parked at the mayor's office. The defendant was with the mayor. And we know why he was there. Because by then, the defendant had already hired the private investigator, already found out his promotion was on the line, and already wrote that fake article. The defendant was just there to put the nail in the coffin. Members of the jury, the mayor had no choice but to use eminent domain, because when the weight of her career was on a knife's edge, when she saw the defendant's grip over her future, she caved. She used eminent domain. Members of the jury, we proved to you that it was because of the defendant's fake article that the mayor forced the sale of the land. You can check off that last box. Now, throughout today's trial, the defense has been telling you that the mayor made mistakes, so the mayor made up a story. I expect they're going to say the same exact thing when they get up here in closing in just a couple of minutes. But when you listen to the defense's story, that's where you find mistakes. Because they tried to tell you the mayor used eminent domain because of unemployment, but the mayor made the announcement in August. Unemployment had been an issue since January. And the defendant brought the Sahara deal in March. If the mayor really wanted to use the warehouse to raise unemployment, there's no reason why she would wait for months and months for unemployment to get even worse. Members of the jury, you even heard from Lakes that it wouldn't be smart for the mayor to support the warehouse. There was a group that was actively opposing it. The defense, they've given you a story, and they sure have made a lot of mistakes. And remember, our burden was only proof beyond a reasonable doubt. So if you look at their story and see the mistakes and decide it's not reasonable, then we've met our burden. And the defendant, she thinks she can use her power to cross the line the law has drawn. That for a promotion, he can choose extortion. He might have tried to scare the mayor into silence. But he can't silence your voice. So find him guilty. Thank you.
Thank you, Attorney Ferris. Attorney Bully. Please proceed when you're ready.
Yes, Your Honor. Your Honor, Ms. Ferris, members of the jury. She made a mistake, so she made up a story. It's September 1st, 2022, and Mayor Sullivan is losing re-election. She just announced that she's forcing the Sahara Deal. After looking at the polls, talking to the community, she made the wrong call. The news was saying her career was over. Her staff told her she made a mistake. As she considered her chances of re-election, she realized she needed a story to shift the blame. So she made one up. She went to City Hall before anyone else was there, opened up her laptop and printed the folder she needed to clear her name. She made a mistake, so she made up a story. Now the prosecution, they tried to tell you something else. They want you to believe that Mr. Whitley blackmailed the mayor. Well, when they bring the mayor's story to court, they need a whole lot more than approval ratings. They need evidence. Today, the state took on a burden to prove three things beyond a reasonable doubt. First, that Mr. Whitley threatened the mayor to release a secret. Second, that Mr. Whitley used fear to manipulate. And third, that he got what he wanted because of that fear. They had to prove each and every one of these elements beyond a reasonable doubt. That's the highest burden in our legal system, members of the jury. That means when you go back to deliberate and you think it's reasonable, that maybe Mr. Whitley didn't send that folder. If you think it's reasonable that Mayor Sullivan just made this up, you can't find my client guilty. And I want to straighten out the burden from what Ms. Ferris told you. As the defense, we don't have a burden. We didn't have to call any witnesses or bring any evidence. It's not our job to tell you that the mayor made up that story. It's the prosecution's job to tell you she didn't. They couldn't do that today. Let's talk about all the reasons why. And we'll start with the mayor's mistake. Today you heard that she was up against a giant, unemployment. She'd been fighting that giant for months. On her closing argument, Ms. Ferris said, well, unemployment's been around forever. It couldn't possibly motivate her. Members of the jury, that's the point. She made a promise a decade ago that she would bring jobs to Midlands, and she hasn't been able to deliver. So when Mr. Whitley pitched the idea of a warehouse to her, she was ecstatic. Finally, after all those years, she has a solution. That's why when she announced that she was forcing the deal, she called it the best thing for Breckenridge. Well, today you learned just how wrong she was. Because after she made that announcement, her approval rating tanked. The news said that was a dagger to her career. Her own staff said that was the worst call you could have made. She realized she needed a story to blame someone else if she wanted to keep her job. And just a moment ago, Ms. Ferris told you, well, the mayor didn't have a choice. But you know that's not true. You heard today all the choices that Ms. Sullivan had. When she found that folder, she could have chosen to call the police. She could have chosen to check those security cameras. She could have called her secretary and say, hey, I think someone was in my office. Can you help me? She didn't do any of that. And there's one reason why. You don't tell on yourself when you're telling lies. I mean, think about the story the state wants you to believe. How did that folder get on the mayor's desk? Because I talked to Miss Sullivan about it, and she said, well, I don't think he walked through the window. We asked the lead investigator for the prosecution, hey, do you know who touched that folder? He said, I don't know. They never looked at security footage. They don't have an eyewitness. They don't even have fingerprints on that folder, members of the jury. But they want you to believe that Mr. Whitley broke into City Hall, made it all the way to the mayor's office, and got back out without anybody seeing him. Mr. Whitley's not Santa Claus, members of the jury. He can't ho, ho, ho his way down the mayor's chimney, leave a present, and get out before she wakes up. In fact, the only thing that this story about Mr. Whitley and Santa Claus have in common is that they're both fake. She made a mistake, so she made up a story. She chose Mr. Whitley to be the villain. That was a pretty good choice. He's a businessman. He's new to Breckenridge. He wanted to come in and shake things up. It was all too easy for the mayor and her board secretary to point the finger. And let's talk about that secretary, the undercover cop. Because today you heard he sat for a year, taking the mayor's calls, watering the mayor's plants, making the mayor's meetings, and found nothing. And then all of a sudden, he finds a textbook example of extortion. After a year, he finally gets to do something that makes him feel like a real cop again. You gotta ask yourself if you can trust the word of a liar. Because you heard he lied before. Under oath, he falsified evidence in an official police investigation. He lied in the past, and he lied again today. I mean, consider that handwritten note that he said he found. He wants you to believe he went to Mr. Whitley's office, found that note, took a picture, and left it there. And when the rest of his team came back to follow up on his work, to double check what he found, it's not there. He said, well, it was a while later. Why would Mr. Whitley take the note but leave the blackmail? Members of the jury, that's absurd. This is a case about public servants who choose to serve themselves. The mayor made a mistake, so she made up a story. Mr. Whitley's going to pay the price. This is just another stop on the mayor's campaign trail, but the lies end here. Today, your job is to consider the facts, consider the evidence, and that's something this prosecution just doesn't have. Ms. Ferris told you he chose extortion for a promotion. Members of the jury, Mr. Whitley wouldn't ruin someone's life for a warehouse. Do what the law requires, what justice demands, and what Mr. Whitley deserves. Find him not guilty. Thank you.
Thank you, Mr. Bully. Ms. Ferris, any rebuttal from the state?
Yes, Your Honor. May I proceed?
Go ahead.
The defense just told you we're here because someone made a mistake. They're shifting the blame. Because the person who made a mistake was Kendall Whitley, the defendant, who went a step too far, used extortion to get a promotion. They tried to tell you Mayor Sullivan set this all up. But members of the jury, when you go to deliberations, I want you to focus on these two documents. Take your time, compare the two. You'll have a hard time believing they weren't written by the same person. And remember, one of them was found in the mayor's office, and the other was found in the defendant's. The only reasonable explanation for these two similarities is that the defendant chose extortion in order to get his promotion. So find him guilty. Thank you.
Thank you, Attorney Ferris, and thank you, everyone. Before I turn it over to our reps and my co-judges, I first just want to thank all the folks that really made Rookie Rumble possible this weekend. First, I want to thank the folks who were responsible for writing the case. So Elise Wilson, Brad Wambo, Brandon Benjamin, and Dennis Kerwin, thank you for this incredibly fun and yet complex at the same time for witness case that they wrote on very short notice. This was a lot of fun to get to judge tonight, and I hope you all had fun preparing it and trying it for 4 rounds, and for these two teams 5 rounds this weekend. So thank you to Elise, Brad, Benjamin and Dennis. And then obviously our group of folks who helped make sure that the tournament actually happened this weekend. Adam Selkov, who was just on the screen, Liz Grant, Ryan Candon, and of course our co-chairs, Natalie Garson and Jeremy Zarzicki. I'm so incredibly proud of all the hard work that you did to make this tournament happen. I'm so happy that we had such great interest and turnout for it. And I hope all of you who participated had a great time, and it's thanks to all of their efforts making it happen this weekend. So thank you to all of you for making the Rumble happen. With that, I'm happy once all the ballots are in. I need to score the last closing.
If the judges could each type in the chat when they're done with their ballot, that'll submit it on our end. I see 2 that are done, 3, 4, 5. Great. While the other reps go tabulate the results, if all the students and judges could come back on, we'll give a few brief comments and then we'll get the results out.
All right, well, let's go in the same order that we went to introduce folks. So let's start with Nat Warner.
Sure, all right. Can you all hear and see me okay? No, I'm kidding. I know you can. All right, the first plaintiff witness, I thought you did a terrific job. You are such a talented storyteller. I thought the accent was additive. I don't think it was distracting at all. I thought you absolutely killed it on cross. You were so credible. You were so likable the entire time. Really great job. Second P witness, super funny jokes, like really well written one-liners throughout. That was great. And you had fantastic energy. I mean, I'm sure you are all more than tired, and you still came in and you just brought the whole round up. You lit up the screen. Really great job. First D witness, I absolutely loved the character. It felt real and well-rounded, but still interesting. And that's a really hard thing to do because you were communicating so many really complicated facts. So I thought you just did a great job with that. And the second D witness, I thought you did an amazing job telling a really clear story. I mean, it's hard to be a defendant, but I thought you just did a great job giving the alternate version of events. And you just came off really credible the entire time. So great job. Haley, I thought that your pacing and your tone throughout the round were just absolutely outstanding. It made everything really easy to listen to and really easy to follow. Lydia, I thought you had phenomenal objections, really technical stuff, really well done. And I thought you had just such a great and powerful presence on both cross and closing. It was really, really fun to watch. Emberlyn, I thought you had amazing reactivity, both on cross and on direct, and not just following up on questions, but the way that your face would change when the witness said something fun, you would smile, you weren't just sort of standing there. That was brilliant. It made you feel like a real person. That was really great. And then Elijah, I thought you just had a really great job on direct, which is a very hard thing to stand out on as an attorney. You did a great job sounding invested and using signposts to sort of move through it. It really helped me engage because it felt like you were enjoying yourself and that you were really engaging. So really great job, everyone. I hope you both won.
All right, let's go next to Mr. Wombo, if he's still here.
Hello. Sorry, I'm on my iPad, so I can't quite see myself. First off, I want to say good job, everyone. This was a really entertaining round to watch. I watched a few of them, obviously, this weekend. It's the only time I get to do it. And as a case writer, it's fun to see how you bring it all to life. I thought you guys caught a lot of the things that we had put in that I hadn't seen people catch, like the prosecution. You caught the whole issue with the similar language. I remember literally just copying and pasting it in them. Let's see if they catch it. So Good on you for that. Defense, you also caught a few of those, like with the whole envelope on having the same information, the missing handwritten note thing there. Like you guys caught that, so I was really happy because I didn't see a lot of people latch on to those points this weekend. So maybe that's why you two are where you are. I won't go side by side, but I'll say that you guys really entertaining, very credible witnessing. You know, my comments are here. Some of them are specific, but mostly I'm trying to like see what you guys can do going forward. Be very proud of yourselves. Good job. Congratulations.
Thank you, Brad. Let's go to Elise next.
No, I'll be quick. This was a really stellar round. As a case author, there's nothing better in the world than getting to see a really stellar round with your case. I was just really impressed the whole time. If y'all, I don't know if they give you comments, I'm assuming they do. If you read them, you'll just see me being like, oh, this is very good. Great job. Wow. A whole bunch of different times, which is not like, usually I'm a pretty mean judge / person. And so I just want to give you my hats off, and you know, I'm pretty sure I tied the thing. So yeah, great job.
Thanks, Elise. Professor Liebhart.
I agree with all my co-judges. Best round I have seen, and I've seen before this. So it is just fun to watch extraordinary mock trial. And this was extraordinary mock trial. Your timelines were very well done. Your organization was phenomenal. I'm just going to mention a couple of high points. The third grade teacher who goes to become a politician to help children. I mean, you know, credibility builder off the rip, and did it in such a short, succinct manner. And then no matter how many times I read this case, I never saw Santa Claus coming. So you guys were just really creative all the way around. And I could continue to talk about your creativity, but I'm gonna let your co-judge take over.
Thank you, Professor Liebhart. And I think I'm the last one. So just really quick on the attorneys, something that you'll see in a lot of my comments for several of you, which I don't think I'm going to have any personal success in outlawing in AMTA, but there was a little bit, and I think this is definitely from attorneys on both sides of the quote unquote the mock trial voice. And I just find that that's something that I think really detracts from your presentation, especially when you are being judged by people who see a lot of mock trial. That when you do hear someone who doesn't have it, it's really very refreshing to hear someone that doesn't use it. So in particular, Ms. Ferris, I found that I really didn't hear much of that from you, which was great. I really felt like I was hearing your authentic self. Ms. St. Hilaire was interesting. I felt like you were using it at times, and then at times you weren't, and I really wanted you to keep in the mode where you weren't using it, because again, I felt like it was your more authentic self, and I really liked it. I really liked sort of the quizzical facial expressions you were making when the witness you were crossing was saying something that like just didn't make any sense. You're like, wait, you're saying what? And I really liked those moments, and the moments where you're using the sort of mock trial cliche type of things just don't land quite as well. So that's my main comment for the attorneys. For the witnesses, particularly Cole and Ethan, and to a little bit lesser extent Hannah. It's just me. You're lovely people. I'm just not a big like jokey accent witness kind of person. So when you see the comments, it's not that I don't think you're lovely people. You're lovely people. I'm glad you're here in the final round of Rookie Rumble. It just doesn't land for me. So certainly to Anthony, I really enjoyed your witness presentation, because again, I think when a jury is seeing, for example, a police investigator, you expect it's going to be someone who's taking it seriously in all business, and when they're kind of smiling and making jokes, again, to me, it doesn't strike me as something that's believable or credible. that's something that different judges have different viewpoints on. So again, that's just where I'm coming from on it. Nothing personal to you guys. So that's just my 2 cents. Thank you all and congratulations. This was a lot of fun. I hope you had fun too.
All right, our ballots have been tabulated. If I could get Jeremy, unless he is no longer with us.
I'm here.
All right. Well, congratulations to everybody. We had a great time hosting you all this weekend. This was a really great round, and we're really appreciative of your guys's great teamwork and participation and just the good attitudes you guys had about being back on Zoom. So thank you very much for that. And I will go ahead and turn it over to Jeremy for the results.
All right, so the final results, we have it was a split verdict, and ultimately we had a split of 4 ballots to 1 ballot. All ballots were super close. And the end result is that the winner is defense.
So congratulations to both teams, Team 46 Defense, Ethan Donovan, Elijah Bully, Anthony Palacios, Emberlyn St. Hilaire, and your tech chair, Max Fritz. Congratulations. And a great congratulations as well to our runners-up, Team 32, Hannah Lee, Cole Alfano, Haley Faroki, and Lydia Ferris. It was an absolutely wonderful round, and thank you all of us for joining on YouTube. We can go ahead and stop the live stream now. And we hope
before you stop the live stream, can you tell us what school those teams are from?
We'll let them.
The defense is from the University of Chicago.
The prosecution's from UCLA.
Excellent. Well, congratulations to both teams. It was a great round. And now we can stop the live stream.